Canadian drivers, if you think the 2026 driving law changes are only about big new rules, you may be missing the one small update that could quietly cost you far more than you expect. Most people are focused on the headline numbers, the $2,000 fines, the license suspensions, the new distracted driving penalties. And yes, those are real and important. But buried inside the 2026 updates is one specific change that looks small, sounds technical, and reads like a paperwork adjustment. That is exactly why most drivers are walking right past it without a second thought. By the end of this video, you will know exactly what it is, why it matters, who is most likely to get caught by it, and what you can do right now to make sure it does not cost you. Stay with me. This one is worth every minute. Canada has been gradually tightening its driving laws for the past few years. That is not a secret. Road safety statistics, rising collision numbers in urban areas, and advances in enforcement technology have all pushed federal and provincial governments to take a harder look at how the rules are applied on Canadian roads. What changed in 2026 is not just the size of the fines. The whole system of how your driving history is tracked, how past offenses are counted, and what a single slip behind the wheel can now trigger. All of that shifted at the start of this year. Provinces like Ontario have been leading the way, introducing updates under the Highway Traffic Act that affect millions of everyday drivers. Other provinces are watching closely and aligning their own rules. So even if you do not live in Ontario, these changes represent where Canadian driving enforcement is heading coast to coast. But here is what most Canadians do not realize. The changes getting all the attention, the big fines, the distracted driving crackdowns, the impaired driving headlines, are not actually the changes that will catch the most drivers off guard. The update that will quietly trip people up is the one that sounds the least dramatic. It sounds like a policy adjustment. It sounds like something for lawyers to worry about. And that is exactly the problem. So what is this small rule change? It has to do with something called the look-back period. And if you have never heard that term, you are not alone. Most everyday drivers have not. Here's how it works. Every time you get a roadside suspension or an alcohol or drug-related driving offense recorded on your file, the law looks back at your history to decide how serious your current situation is. If you had a previous offense within a certain number of years, you are treated as a repeat offender. Repeat offenders face much harsher penalties, longer suspensions, mandatory treatment programs, ignition interlock requirements. The works. Up until the end of 2025, that look-back window was 5 years. 5 years is a long time, but many drivers had something on their record from 6, 7, or even 8 years ago. They had moved on. They figured it was old news, gone from the system, no longer counting against them. As of January 1st, 2026, that look-back period was extended from 5 years to 10 years. This is where things get tricky. If you had an alcohol or drug-related driving occurrence 8 or 9 years ago, something you thought had already aged off and disappeared from how authorities count your history, it is now back in play. A new offense today does not start fresh the way it would have in 2025. That old occurrence gets pulled back into the picture, and that can be the difference between a first offense outcome and a repeat offender outcome, with all the extra penalties that come with it. Now let us connect this to something even more important. The 2026 law changes did not just extend the look-back period, they also strengthened the penalties for what is called the WARN range. The WARN range is a blood alcohol level between 0.05 and 0.079. That is not legally impaired. The legal limit in most provinces is 0.08. But reaching 0.05 is enough to trigger what is called an administrative roadside suspension. Think about what that actually looks like in real life. You go out for dinner, you have a glass of wine, maybe 2, depending on your size, your meal, and how quickly you drank. You feel completely fine. You drive home without any trouble. But if you were pulled over and tested, and your blood alcohol came back at 0.05, you would have an administrative suspension on your file. And this next part is very important. In 2026, a first-time WARN range suspension now means 7 days off the road. That went up from 3 days. A second occurrence means 14 days. And here is where the extended look-back period ties back in. If you had one of these worn range suspensions 6 or 7 years ago and completely forgot about it, that now counts. If you pick up another one today, you are not treated as a first-time case. You are treated as a repeat offender. Most drivers hearing this right now are realizing they never fully understood the worn range to begin with. Many people believe that as long as they are under 0.08, nothing happens. That is not true, and it has never been true. But in 2026, the consequences for being in that worn range have gotten sharper, the penalties have grown, and the history of your past is now following you twice as far back. Let us put this into some everyday situations so you can see how easy it is to get caught by this without ever feeling like you did something wrong. Think about a busy parent doing the school pickup run after a work lunch where one beer was ordered, or a senior who has a glass of wine every evening with dinner, drives short distances in a familiar neighborhood, and has never thought twice about it. Or a newcomer to Canada who came from a country where 0.05 was not considered meaningful and who simply did not know the worn range existed here. Or a daily commuter who had a minor roadside issue 5 years ago, assumed it had been long forgotten, and now learns that the new 10-year window means it is still on the record. These are not reckless people. These are ordinary Canadian drivers. And this is exactly the group that the extended look-back period and the tougher worn range penalties are going to affect the most in 2026. But here is what most Canadians do not realize. Enforcement in Canada is not just relying on the old ways anymore. Technology is improving. Roadside screening tools are more common. Police can now review a longer window of your driving history on the spot. This is not about government overreach. It is about the reality that the tools available to enforce these rules have grown stronger, and the legal structure supporting those tools has expanded with them. So who is most likely to miss this change completely? Seniors who drive the same familiar routes and have not reviewed the rules in years? New immigrants who are still adjusting to Canadian road laws and may not know about the administrative suspension system at all? Busy commuters who skimmed the driving news, saw the word impaired driving, assumed it did not apply to them, and moved on. People who had a minor roadside suspension 5, 6, or 7 years ago and assumed time had cleared it. And drivers who simply rely on old habits and old assumptions about what the rules allow. None of these people would describe themselves as bad drivers. That is the point. This change is not aimed at reckless people. It catches careful everyday drivers who just did not get the update. And this next part is very important. The consequences are not just a fine you pay and forget. A 7-day roadside suspension means no driving for a week. If you depend on your car for work, for picking up children, for medical appointments, for groceries, that is a serious disruption to your life. And if the suspension is treated as a repeat offense because of that extended look-back period, the outcomes get heavier. Ignition interlock programs can be required. Remedial programs must be completed. Your insurance company will almost certainly notice the mark on your record, and your premiums can rise as a result. These are not outcomes reserved for drunk drivers. These are outcomes that now reach further into the everyday driving population than they did before. So how do you check whether you are in a safe position going into 2026? The first step is simple. Think honestly about your driving history. Did you have any alcohol or drug-related roadside incidents in the past 10 years? Not just convictions. Administrative suspensions count too. If you are not sure, contact your provincial transportation authority and request a copy of your driver record. In Ontario, that is the Ministry of Transportation. In British Columbia, it is ICBC. In Alberta, it is Service Alberta. Every province has a process for this, and pulling your own record costs very little. The second step is to revisit the worn range rules in your province. Know where the 0.05 line sits. Understand that being under the legal 0.08 limit does not mean you are in the clear at a roadside stop. The worn range starts much lower, and it now comes with consequences that many drivers were never expecting. The third step is to update your habits around alcohol and driving. This does not mean never having a drink at dinner. It means understanding that even a single drink can put some people into the warn range depending on their body weight, their metabolism, and how much they ate. Giving yourself more time after drinking before getting behind the wheel is the simplest protection you can give yourself. And if you are a newcomer to Canada, please make sure you are reading your provincial driver's handbook with current editions. Rules change. What you learned when you first arrived may already be out of date. Here is the good news, and it truly is reassuring for most people on the road. The vast majority of Canadian drivers who stay informed and follow normal safe driving habits are very unlikely to face any negative impact from these updates. The extended look-back period does not create new violations by itself. It simply allows authorities to review past records if a driver already has alcohol-related or serious driving incidents on file. If your driving history is clean, there is essentially nothing new for enforcement systems to flag. In practical terms, careful and law-abiding drivers will continue driving exactly as they always have, without any added penalties or surprises. It is also important to understand that the warn range penalties are not automatic for everyone. They only apply if a roadside test shows a blood alcohol reading of 0.05 or higher, which is the caution zone in many provinces. Drivers who plan ahead, avoid risky situations, and make responsible choices before getting behind the wheel generally stay well below this threshold. Yes, enforcement tools and roadside checks are becoming more advanced, but the main goal of these updates is prevention, not punishment. Officials are trying to encourage drivers to stay alert, make safer decisions, and remain aware of current rules. For informed drivers who take basic precautions, these changes should feel more like a reminder to stay sharp rather than something to fear. The government is not trying to trap ordinary people. These are public safety improvements designed to reduce accidents and save lives on Canadian roads. The best way to stay fully protected is simply to know what the rules are and stay slightly ahead of them. Which province are you watching from? Drop it in the comments below. It helps to know where you are coming from, because the way these changes apply can vary between provinces, and your location matters. If this video helped you understand something you did not know before, please hit the like button. It truly helps this channel get information like this to more Canadian drivers who need it. And for clear, honest updates on Canadian driving laws, CRA changes, pension updates, immigration news, and more, subscribe to this channel. We keep it simple, and we keep it Canadian. Just a quick note before you go. The information shared in this video is for general awareness only. Driving laws and administrative rules in Canada are set at the provincial level, which means the exact details, penalties, and enforcement practices can vary depending on where you live. What applies in one province may be slightly different in another. On top of that, regulations can be updated with little notice as governments adjust safety policies and enforcement tools. That is why it is always a smart step to double-check anything that directly affects your license, vehicle, or driving record. For the most accurate and up-to-date guidance, contact your provincial transportation authority or visit their official website. Our goal is to keep you informed and prepared, while also pointing you to the right official sources for decisions that affect your personal situation. Now you have a clear understanding of the extended look-back period and why the warning range is getting much more attention in 2026. Many drivers will never hear about this change until it is too late. They will assume their old habits are still safe, and that is exactly where problems can start. But you took the time to watch carefully and stay informed. That already puts you in a stronger position than thousands of drivers who may get caught off guard in the months ahead. Awareness is often the difference between a clean record and an unexpected penalty. Stay safe every time you are on the road, and make it a habit to stay updated as rules continue to evolve. In the next video, we will break down another important update that is quietly affecting hundreds of thousands of Canadians across the country, and this one is not related to driving at all. If you like staying one step ahead of these changes, you will definitely want to watch what is coming next.